And now we begin what might be the most important part of the semester, contract law. How do we define a contract? A contract is an agreement that can be enforced in court. A contract may be formed when two or more parties each promise to do or refrain from doing something now or in the future. A party who does not fulfill his or her promise may be subject to sanctions, including damages, that means they pay money, or in some circumstances, being required to perform the promise. This is referred to as specific performance. Now, trying cases, particularly contract cases where both parties think they're right, can be very expensive and they can take a lot of time. So when a case is brought before the courts, before they do anything, the first thing they must do is determine whether or not the parties actually intended to enter into a contract. Now, in order to do this, they use something called the objective theory of contracts. A contract is judged by outward objective facts as they would be interpreted by a reasonable person rather than a party's own secret subjective intentions. Now, I want you to think about that. A reasonable person. What's a reasonable person? That's an average person, a regular person, not a genius, not a moron, someone who is in the middle, someone who has common sense. Now, why is this important? Well, you look at what's written in red, a party's secret subjective intentions. A lot of times when people hear things, they hear what they want to hear. They don't necessarily hear what was said or what was meant. Now, in order, objective facts, the court asks 3 questions. First, what did the parties say when entering into the contract? 2, how did the party act or appear when entering into the contract? And finally, what were the circumstances surrounding the transaction? Now, if you take these questions one at a time, it may lead you to believe that a contract does in fact exist. But when you take them all together, it can become very, very clear that the parties did not intend to enter into a contract. Let's say you're walking down the street and you see a young mother with a monstrous child. This kid is yelling and screaming, having a temper tantrum, throwing things all over the place, breaking things, hitting the mother. And the mother looks at the child and says, "If you don't act correct this minute, I will sell you for 50 cents to the first person to come by." Now you happen to hear this, so you welcome and say, "I accept your offer. I will take that child for 50 cents. The mother looks at you like you're crazy, but you sue the mother for breach of contract. Now, if you refer to the objective theory contracts, what did she say? She said, "I would sell this child for 50 cents. How was she acting, or how did she appear? She appeared to be angry. She appeared to be upset. She appeared to be at a loss. What were the circumstances surrounding the transaction? Well, you had a monstrous little kid acting up. What would a reasonable person infer after asking these 3 questions? You're right. The mother didn't want to sell the child. She was just frustrated. There is no contract. Now, contrast this from maybe you're walking by a used car lot. You see a sign on a car that says for sale $5,000. Assuming the car is worth $5,000, would a reasonable person infer that the dealer was offering to sell the car? The answer should be yes. Why? Based on the objective theory of contracts. What did the sign say? Car for sale. How did the dealer appear or act? Eager to do business. What were the circumstances surrounding the transaction? You were in a car lot. Slam dunk, that's a contract. Now, there are some very specific requirements for a contract. We call these requirements elements. Now, there are four essential elements. The first is an agreement. The agreement has two parts: an offer and an acceptance. One party must offer to enter into a contract, and another party must accept that offer. Element number two is consideration. Consideration is the thing of value that induces the parties to enter into a contract. Now, the key is consideration can be anything whatsoever. It could be a trade, something for something. As you see with the illustration, a piece of meat for a fish. It could be money. It could be a promise to do something in the future. And it could also be a promise not to do something that you have a legal right to do. Element number three is contractual capacity. Contractual capacity has two components: authority, the authority to enter into a contract, and ability, the ability to understand your rights and obligations as they arise from the contract. Now, this is pretty easy. Why? Because as a general rule, the law perceives everyone as having both the authority and the ability to enter into contracts for themselves. Now, you notice what I said. As a general rule, the law perceives everyone as having both the authority and the ability to enter into contracts for themselves. Now, because I said as a general rule, you know that means there must be an exception. And there are three: minors, intoxicated people, and the mentally incompetent. Now, just so you know, a minor is anyone who's not yet reached the age of majority. And in most states, the age of majority is 18. Now, the law states that a minor has an absolute right to enter into a contract as long as it is legal to do so. Now, that tends to mean that there is no age requirement to the contract. Some contracts require you to be an adult to enter to them, so a minor could not enter into those types of contracts, but they have an absolute right to enter into any contract that doesn't have that sort of prohibition on it. Now, a minor also has the right to disaffirm the majority of contracts he or she enters into anytime prior to reaching majority, or for a short time thereafter, 2 years, unless the minor ratifies the contract upon reaching majority. Now, I've just said a whole lot. Disaffirm simply means get out of. A minor has the right to disaffirm, get out of, the majority of contracts he or she enters into. Now, you notice I said majority because they can't get out of all of them. A minor cannot disaffirm a contract dealing with child support, federally guaranteed student loans, and bail bond agreements. Next thing I said was unless the minor ratifies the contract upon reaching majority. Well, here's the thing. Generally speaking, with those three exceptions, minors cannot ratify contracts. Ratify simply means agree to be bound to. Right? So the minor has until he or she turns 18 to change their mind unless they ratify the contract when they turn 18. Now, if they agree to be bound to a contract upon turning 18, upon reaching majority, they cannot change their mind. Now, in some circumstances, the law extends that time for an additional 2 years. Right? Things can happen where the minor may not have ratified the contract generally by using the subject matter of the contract, but they don't disaffirm it when they turn 18 either. For example, let's say you got a young man who is 17 years old, driving his car up and down the roads of North Carolina very recklessly, runs into a power pole, knocking it down. The kid is arrested for driving recklessly. And at his hearing, right, the judge suspends his license until he turns 21 and tells him he may not drive a car in the state of North Carolina until he's 21. Further, the judge gives him a choice. He can either go to jail for the damage that he's done, or upon graduation from high school and turning 18, join the military. Now, the kid is a good-looking boy, so he does not want to get locked up. So what does he do? He takes the option of going into the military. So he parks the car in his dad's garage and goes on and finishes up his next year in high school. Just so happens his birthday is 1 week before the semester ends. So he turns 18, he graduates from high school, and the next week, his father takes him to the recruiting station where he joins the Army. A week later, he's sent to Fort Benning, Georgia, where he does basic training and his AIT. Upon completing basic training and AIT, he's sent to Germany. He doesn't have leave for 18 months. When he comes back home for the very first time, he's 19 and a half, more than 18. But he did not ratify that contract when he turned 18. Why? He didn't touch the car. He didn't drive the car. He did not use the subject matter of the contract. So what does he do? He calls up the dealer and he says, you know what? I've got this car that's just been sitting here for years. I don't want it anymore. Come and get it and give me my money back. Now, because he hadn't ratified the contract when he turned 18, the law says he has until he's 20 to get out of the contract. And when he gets out of the contract, the other party has to return to the minor all of the consideration that the minor paid. Now, had he made one mistake, had he come home and decided that he didn't want the car anymore, so he was going to take it back to the dealer, if at 19 and a half he got in the car and he drove to the dealer, he wouldn't be able to get out of the contract. Why? Because he used the subject matter of the contract after reaching majority, after turning 18. Now, the second group that's given special consideration are intoxicated people. If an intoxicated person enters into a contract, that contract becomes voidable at the intoxicated person's option if he or she can prove that at the time they entered into the contract, they were so intoxicated that they did not understand their rights and or obligations as they arose from the contract. Now, you notice what I said. They have to prove that they were so intoxicated they did not understand their rights or obligations. They did not know what they were doing because they were either so drunk or high. Well, how do you prove that? You can't just say, I was so drunk I didn't know what I was doing. The law requires that you present 3 witnesses. You have to present a medical expert, and this is a doctor, who will testify based on what alcohol or other drug you consumed, the amount, the quantity, the time over which you ingested it, the other things you ingested at the same time, your gender, your age, your height, and your weight, whether scientifically it was more likely than not that you were intoxicated to the point that you did not understand what you were doing. The second witness is an expert witness. This is going to be a bartender or a server who's used to dealing with intoxicated people. And they will have to testify in their expert capacity whether you appeared to them to be so intoxicated you did not understand what you were doing. And of course, the third witness will be a lay witness. This is someone with no special skills. They're not a doctor. They're not a bartender or a server. And they just testify as to what they saw. Now, all three of these witnesses, their testimony has to state that you appeared to be, or that you were scientifically so intoxicated you did not know what you were doing. Now, the fourth element, and probably the easiest, is legality. Legality simply states that a contract must be for a legal purpose. So obviously, I could not enter into a contract with you to go rob the liquor store across the street next to Whole Foods. Why? Because robbing a liquor store is illegal, so we couldn't enter into a contract to do it. Now, just because you have all four elements to a contract, it doesn't automatically mean that the contract is enforceable. There are some defenses against the enforcement to an otherwise valid contract. First, we have genuineness of assent. Genuineness of assent or mutual assent exists when consent is not clouded by fraud, misrepresentation, duress, undue influence, or mistake. A party who can demonstrate that he or she did not genuinely assent to the terms of a contract may void the contract. Now, when we say demonstrate, you have to prove it. You got to show that you didn't actually agree to the terms of the contract. Now, let's think about this. Fraud. What's another word for fraud? Lie. If you enter into a contract based on a lie, had you known the truth, would you have entered into the contract? There's a possibility that you would not have. So your assent is not genuine. Misrepresentation? Well, that's fraud. Someone tricks you into entering into a contract. They misrepresent as true some fact or condition that is not true. And based on that representation, you enter into a contract. I'm a used car dealer, and I tell you that a car has 25,000 miles on it, when in fact it has 250,000 miles on it. Because you thought it had 25,000 miles on it, you bought the car. Would you have bought it if you knew it had a 250,000 miles on it? Probably not. Your assent is not genuine. Undue influence. Undue influence occurs when one party has such influence over another party that that second party has no free will of its own. If you have no free will, if I have such control over your mind that when I tell you to do something, you do it, and I say, you will sign that contract right now, and you say, yes, sir, and sign it. Since you had no free will, was your assent genuine? Was it something you wanted to do? Probably not. What is duress? Duress is a threat. If I threaten you with death or serious bodily harm to induce you to enter into a contract, the question is, would you have entered into the contract without the threat? Probably not. The contract would not be enforceable. And then finally, you made a mistake. Question: had you known the facts as they truly were, is there a possibility you would not have entered into the contract? The answer is yes. Once again, your assent is not genuine. Second defense is form. Contracts come in two forms: formal and informal. Formal contracts are those under seal or record. Record means it's entered to the records of the court, right? Sometimes with loans that are big loans, right? You make an official record to the court that you've taken out this loan. That's a formal contract, right? Now, under seal is exactly what it sounds like. This comes from, the medieval times when a lot of people couldn't read or write, but most nobles and officials would have a symbol. And if they wrote a document, the way they let everybody know it was from them is they drop some wax on the document and then they press their seal into the document, right? That's a contract under seal. Now, all contracts under seal are written. All contracts under seal are written. The second type of contract is an informal or a simple contract, right? Also known as parole contracts, right? And these include all contracts that are not under seal or of record. Informal contracts can be oral or written. Important point that makes this really easy is that the majority of contracts, almost all contracts, are informal contracts. Another rule that makes it really easy, as a general rule, with the exception of 5 contracts that must be in writing to be enforceable, all contracts are enforceable, whether oral or written. I'm going to say it again. With the exception of 5 contracts which must be in writing to be enforceable, all contracts are enforceable, whether oral or written. And to make this really easy for you, I'm going to tell you the 5 contracts that must be in writing to be enforceable. Number 1, a contract for the sale of goods, $500 or more, must be in writing to be enforceable. Number 2, contracts dealing with interest in real property, that is land or anything permanently fixed to the land, must be in writing to be enforceable. Number 3, contracts guaranteeing the debt of another must be in writing to be enforceable. This is co-signing a loan, co-signing a mortgage. Number 4, a contract that by its terms cannot be completed within 1 year must be in writing to be enforceable. And when I say cannot, that means impossible to complete within 1 year must be in writing to be enforceable. And number 5, contracts in consideration of marriage must be in writing to be enforceable. We're talking about prenuptial agreements, antenuptial agreements, and dowry agreements. All right, we have a few basic rules for contracts. First, it's the freedom of contract and the freedom from contract. The freedom of contract is the right to enter freely into contractual arrangements and is considered to be a fundamental public policy. Courts generally do not interfere with contracts that are voluntarily made, right? Now, if it's voluntarily made, generally the assent is genuine. The assent is sincere. Now we have to talk about how we classify contracts. Each of these categories signifies a legal distinction regarding a contract's formation, performance, or enforceability. I'm going to start off with classification based on formation. Now, first, we have bilateral contracts. Bilateral contracts are formed by a promise on one side in exchange for a promise on the other. Important point. At the time the contract is entered into, should be neither party does anything except promise to do something in the future. Neither party does anything except promise to do something in the future. Today is Monday. If I say to you, if you bake a cake for me on Wednesday, I will paint your kitchen on Friday. If you agree to my offer, what are you doing for me today, Monday? The answer is nothing except promising to do something for me on Wednesday. What am I doing for you today, Monday? Once again, the answer is nothing except promising to do something for you on Friday. Now, an easy way to remember bilateral contracts is to remember a promise for a promise, a promise for a promise. Bilateral contract is a promise for a promise. Now, the second contract based on formation is a unilateral contract. Unilateral contracts are formed by a promise on one side in exchange for a fully completed act on the other. The only way the offeree can accept the offer is by fully performing the required act. I'm going to say this again for emphasis. The only way the offeree can accept the offer is by fully performing the required act. Example, $500 for the return of my little cat Cleo. The only way you can accept my offer to pay you $500 is to bring my cat back to me. An easy way to remember a unilateral contract is the phrase, a promise for an act. A promise for an act. Next, we have classification based on mode of acceptance. First, we have express contracts. An express contract is one in which the terms are expressed in words. The words can be oral or written, doesn't matter. Second is an implied contract. A contract that is implied from the conduct of the parties is an implied in fact or simply an implied contract. The parties' conduct reveals their intent to form a contract and creates and defines its terms. Now, I'm going to take a step back and I want to talk about express contract versus implied contracts for a second. Real simple example of an express contract is if you bake me a cake on Wednesday, I will paint your kitchen on Friday. How do you know what you have to do for me? Well, it's based on my statement. It's based on my words. How do you know what I'm going to do for you? Once again, it's based on my statement. It's based on my words. Now, I can say it orally as I have, or I can put it in writing. Doesn't matter. The terms of the contract are expressed by my words. That implied contract, as we said, is implied from the conduct of the party or the actions of the parties. For example, if you were to go to a restaurant, think about what normally happens. You walk in with one of your friends. The maitre d' says, how many? You say 2. The maitre d' says, follow me. He or she takes you to a table, hands you a menu or 2, that says your server will be with you in a moment. The server comes over. Can I get you some water? You say yes. Then they come back with the water and say, can I take your order? After reviewing the menu, you order what you want to eat. You order what you want to drink. The server puts the order in. 10, 15 minutes later, they bring the food out. You eat the food. And when you finish eating, the server says, would you like anything else? And what do you say? No, just the check. Well, here's the thing. The entire transaction, going into a restaurant, taking a seat, and ordering food, is an implied contract. Based on your conduct, the restaurant knew that if they gave you food, you would eat it and pay for it. Now, this may not be clear, but think about this. In order for that transaction to be an express contract, you would have had to walk in and said, excuse me, young lady, if you seat my date and I at a table that we like and hand us menus, we will look at the menus and see if there's anything we want to eat. If a server comes over in a timely fashion and takes our orders and then brings the food back for us prepared the way we want, if we like it, we will eat it. And after eating the food, if we're presented with a check that we agree with, we will pay the check and leave. Now think about this. Have any of you ever said anything like that when you walk in a restaurant? The answer is no, because people think that you were crazy. But that's what you would have to do for that to be an express contract. Now there are a few more things we have to talk about with implied contracts. First, to establish an implied in fact contract, there are a few requirements. One, the plaintiff must have furnished some service or property. In the case of the example, the restaurant provided you with food. Two, the plaintiff must have expected to be paid, and the defendant, that would be you in my example, knew or should have known that payment was expected. And three, the defendant, that's you, had the chance to reject the service or property and did not. You sat down at the restaurant, you ordered the food, and you ate it, right? If the plaintiff can establish these facts, there's an implied in fact contract. Now, my favorite contract in this particular group, contracts based on acceptance, is a quasi-contract. A quasi-contract is not based on express promise to pay for benefit received or on conduct implying such a promise. Quasi-contracts or contracts implied in law are imposed by the courts to avoid unjust enrichment. Now, hopefully you guys realize that a quasi-contract is not a contract at all. Now, before the courts impose a quasi-contract on the parties, there are three requirements that must be met. First, at the time the benefit was conferred, the party receiving the benefit must not have been in a position to accept or reject the benefit. Two, the benefit conferred must have been necessary. And three, justice would best be served by requiring the party receiving the benefit to pay for the benefit. Now, this is an all or nothing proposition. All three requirements must be met. Let's say I'm jogging down the West Side Highway trying to get back in shape for summer, assuming we didn't have this whole coronavirus going on. Or maybe, as you can hear, I'm running from the police. I decide to cross the highway without looking to see where I'm going. I get hit by a car. I'm knocked in the air. 50 meters, I land smack on my head, cracking my skull open. My brains are oozing out. One of the other runners just happens to be a neurosurgeon. He runs over to me with my brains in the street, scoops them up, puts them back on my head, puts my head back together, and holds me together while waiting for an ambulance to come pick me up. When the ambulance comes, he gets in the back of the ambulance with me. He rides to the hospital with me and tells the ER doctors exactly what happened. 3 weeks later, when I wake up, I meet all the doctors in the hospital that are treating me. A month later, when I get out, I receive a bill from the hospital and a bill from this doctor that I have never seen. I gladly paid the hospital bill, but since I don't know who this other doctor was, the one that I've never seen, I refuse to pay him. What does he do? He sues me in court for breach of contract under the doctrine of quasi-contracts. Now the question is, would he have a good case? The answer is probably. Why? At the time the benefit was conferred, the party receiving the benefit, me, must not have been in position to accept or reject the offer. Here's the thing. I was unconscious. I couldn't say yes or no. The benefit conferred must have been necessary. Had the doctor not rendered aid, I would have died. I think that was unnecessary. Finally, in this case, because time is money, justice would best be served by requiring the party, me, who received the benefit, to pay for the benefit. The question is it fair that the doctor, a neurosurgeon who had real patients, took 3 hours out of his day, 3 hours that he could have been treating his own patients who would pay him, to spend with me? And the answer is no. Right? The courts would require me to pay the doctor for his services. Now, important point on the payment. The payment that the doctor would receive will be the fair market value for the services he rendered. Not necessarily what he asked for, but the fair market value of the service he rendered. And why is this an important distinction? Well, the better you are, the more you charge. Let's say he was the top neurosurgeon in the entire world, and because of demand, his rate was 10 times higher than the average, 10 times higher than the market rate. The law would only require me to pay the market rate, not what he's asking for. Classification based on performance. Contracts are also classified according to their stage of performance. An executed contract is a contract that has been fully performed. An executory contract is a contract that has not been fully performed. If one party has fully performed, but the other party has not, the contract is said to be executed on one side, but executory on the other, and is classified as an executory contract. If you bake a cake for me on Wednesday, I will paint your kitchen on Friday. Now, once again, today is Monday. You've said yes. At this point, we have an executory contract. Wednesday comes, you bake the cake. The contract is executed on your side, but still executory on my side, so it's I'm having trouble talking. So it's an executory contract. Friday comes, I paint your kitchen. Now that you've done everything you promised to do, and I've done everything I promised to do, the contract is executed. It's a fully completed contract. Now, we also have void contracts. Any contract that's missing any one of the required elements is a void contract. A valid contract results when all 4 elements necessary are present. Now, if a contract is void, the contract is no contract. A void contract gives rise to no legal obligation on the part of any party. A voidable contract is a valid contract in which one or both parties have the option of avoiding his or her legal obligations. If a contract is avoided, both parties are released. However, if a contract is ratified, both parties must perform. Now, an unenforceable contract is a valid contract that cannot be enforced due to the enumerated defenses, which are 1, genuine consent, and 2, form. How do we interpret contracts? The most important principle to keep in mind in considering these rules is that the law attempts not just to enforce a contract, but to enforce the contract the parties made. Now, you notice that's underlined. The intent of the parties when contracting is paramount. Now, there are a couple of laws that help the law to do this. The first is plain language laws. The federal government and most states regulate legal writing through plain language laws. These laws cover a variety of consumer agreements, including residential leases, as well as federal and state government forms and other legal documents. If a party to a contract violates a plain language statute, the contract may be void unless it can be shown that the party made a good faith effort to comply with the statute. Well, plain language is exactly what it sounds like. It means that a contract has to be written in standard English. You can't use technical terms where you can use plain terms. You can't use legal terms where you can use plain terms. Right? We call that legalese. Right? Contracts have to be written in a way that people can understand what they're reading. And before these laws were put in place, you had a lot of situations, right, where people put a lot of technical terms in contracts or a lot of legal terms in contract because they understood human nature. Do you know what people hate to be thought of as? You probably guessed it, stupid. So if you put big words in a contract, odds are the person reading the contract is not going to ask you what those words mean because they don't want you to think they're stupid. A lot of contracts are written with that in mind, right? And because of human nature, they took advantage of a lot of people. So laws were put in place to protect people. That being said, one point that I want you to go away with, if nothing else in this class, before you sign a contract, before you agree to anything, make sure you understand everything. The only stupid thing to do is not ask questions and pretend you understand when you don't. A contract is a meeting of the minds. It's two parties agreeing to exactly the same thing. So before you agree, make sure you know what you're agreeing to. All right, now, how do we interpret contracts, or more importantly, how do the courts interpret contracts? Well, plain meaning rule. Once again, when a contract is in writing that is not subject to conflicting meanings, a court will enforce the writing according to its plain meaning. Under this plain meaning rule, the meaning of the words must be determined from the face of the instrument. A court cannot consider evidence extrinsic to the document. This means that the document stands on its own, right? Generally speaking, you can't bring in supporting material. That's what extrinsic means. It's something outside of the writing. When a writing is unclear, a court will interpret the language that gives effect to the party's intent as expressed in their contract. A court will not make or remake a contract, nor interpret the language according to what the parties claim their intent was when they made it. Now, once again, the court is looking to see what the party's intention was when making the contract. That's what this particular phrase means, right? If the parties come and say, well, we're going to do X, Y, and Z, after the fact, they can't say that we're going to do C. In interpreting terms, the following rules apply. If the terms are still susceptible to more than one meaning, a court will consider extrinsic information, right? If it's not clear, then the court, and only then, will they look at things outside of the contract. please pay attention to the following rules. 1. A reasonable, lawful, and effective meaning will be given to all of the contract's terms. 2. A contract will be interpreted as a whole. Individual clauses will be considered subordinate to the contract's general intent. All writings that are part of one transaction will be interpreted together. What does this mean? This simply means that if you've got a contract that's got 20 pages and 300 clauses, if there's one clause that goes against the bulk of the contract, the courts will consider that to be not part of the intent of the contract. And in many cases, they'll remove that clause from the contract and enforce the balance. Real big example of this would be a health insurance contract. All right, some of you probably seen them. They give you these great big books after you sign your policy. Right, and in the books, it has all the things that are covered, usually up front, 12-point Times New Roman font. And as you start getting towards the back of the book, maybe page 200 or so, it starts to tell you the things that are not covered. Right, the font tends to be a little bit smaller. The words tend to be a little bit longer. Well, about 20 years ago, there was a class action lawsuit brought against health insurance providers. Why? Because women, many of them who had been working for 25, 30 years, these are women in their late 40s, perhaps in their 50s, started going to the doctor and they were diagnosed with heart disease. Now, because they've been paying into their insurance policies, they weren't really worried about the cost of care because they knew that they were covered. So they, went in there, diagnosed with heart disease, a treatment plan came up, only to find out that the insurance company wasn't covering it. Right? That was in the part of the contract that talked about all the things that weren't covered. Now, all the rest of the contract, the insurance policy said, we will cover you if you get sick. But it had this one little clause that said, except for this. Well, when the courts looked at it, first thing they said, well, what was the intent of the parties when they signed this agreement? Well, the intent of paying for health insurance is if you get sick, you have coverage. What did the insurance company promise up front? They promised, if you get sick, we will cover you. Here's the thing. 99% said we'll cover you. This one clause said we wouldn't. So you know what the courts did? They went with the intent of the parties and the promises made from one party to another, and they excised those clauses from it, and they forced the insurance companies to pay for those treatments with heart disease. Now, as a point, statistically speaking, right, at the time these contracts were written, women were not diagnosed with heart disease in any significant numbers. That's why they weren't included. Right? The purpose of an insurance company, of course, is to make money. You pay them money so they can invest it, and they really don't want to pay you, right, if you need them. Now, here's the thing. A magic thing happened, probably your grandparents' generation, because with my parents, women started going to work, right? And women would work to retirement age on average, so they got older. Before that, a woman might get a job, and then when she started a family, she would leave the workforce and become a homemaker. Even harder job, but that was the norm. Right, until my parents' generation, when economics necessitated both parties in a marriage working. Well, because women had not worked for as long as men to retirement age, right, no one knew that women were subject to the same stresses that men had at work, right? So women tended not to be shown to have heart disease, right? That's the reason why the insurance companies left it out. Just a side note. Now, moving back to that little second part. All writings that are part of the same transaction will be interpreted together. Well, sometimes a contract is more than 1 or 2 pages. Sometimes it's more than 1 or 2 communications. So if you and I are writing emails back and forth, negotiating the terms of a contract via email, right? All of those emails will be considered one contract. That's all that means. Terms that were negotiated separately will be given greater consideration than terms that were not negotiated separately. This is very, very important, right? When you negotiate something separately, the law believes that you've thought more about it. Now, a lot of times, in order to save money, people don't always go to lawyers when they want contracts. They buy these pre-written boilerplate contracts. A boilerplate contract is very much a standard contract, right? Some of you, maybe now or maybe in the future, might decide that you want to be landlords. You'll buy a 2-3 family home. Perhaps you'll live in one of the units. You'll rent out the other 2. Because you're trying to make money, you don't want to spend money on a lawyer, so you download a Bloomberg lease. Bloomberg is a company that makes pre-written contracts. Now, it's pretty standard. It has all the things that you usually need in a New York City contract. Now, you might decide that you want to add something else. We call this a rider, a separate provision from the main document. You might put something in, you may not have any dogs that weigh more than 30 pounds on this property, right? That would be a rider. That would be something that's negotiated separately from the bulk of the contract. So if the boilerplate contract said you could have dogs with no provision regarding the size, but you wrote that special part saying you can only have dogs up to 30 pounds, the court would give that greater consideration because you thought about it more. A word will be given its ordinary, commonly accepted meaning, and a technical word or term will be given its technical meaning unless the parties clearly intended something else. Now, at first, this might seem like a waste to add as a rule, but we all know that sometimes we speak in slang, and sometimes words have one meaning in standard English and another meaning in slang. Now, if both parties to the contract speak the same slang, and they add a slang term to the contract, and both parties know what they intended by that term, the court will give it its slang meaning as opposed to its standard meaning. Specific and exact wording will be given greater consideration than general language. Contracts are all about detail. The more specific you are, the better you are. You could say, I will sell you my blue car for $20,000. That'd be okay. However, it's much better to say, I will sell you my midnight blue 2017 Escalade for $20,000. Detail matters. It's much better because it's clearer in expressing the party's intent. Written or typewritten by machine terms prevail over printed ones by hand. What does this mean? This means that if you have something that was produced on a word processor, it's given greater weight than a contract that has pen and ink corrections. Right? And the idea is, when you and I sit down and we negotiate the terms of a contract, after we negotiate them, we type them up. You can't go home after signing a contract and change your mind and start crossing things out and adding other things with a pen. Right? If you do that, and I come to a trial with a pristine contract, and you come to a trial with a contract with all these pen and ink corrections, the court has no idea when those additions or subtractions or changes were made. So the court will give greater weight to the one that is pristine, the one that was typed. Now, there is an exception to this, and if you think about this, right, if you and I are negotiating, we got a pre-written contract, and sitting at the table before we sign, there's some things that we want to change. So you cross out a term and you do a pen and ink correction. What would you have me do? You would have me initial or sign it. Right now, if it's initial or sign, then the court would enforce it. Why? Because the court knows that I saw it. Now, of course, those same pen and ink corrections should be on my contract, initialed by you. When the language used has more than one meaning, it will be interpreted against the party that drafted the contract. Now, this is good, and this should be obvious, right? If I put a term in a contract that has multiple meanings, why did I do that? Because I wanted to trick you. I write a contract selling you my blue vehicle for $5,000. Now, what's a vehicle? It's anything that can serve as a mode of conveyance. Right now, I happen to have a blue bicycle, a blue skateboard, a blue motorcycle, and a blue car. You thought I was selling you my blue motorcycle when in fact I was selling you my blue skateboard, because all of these things are vehicles, right? Because I wrote the contract, the law, the court would decide I was trying to trick you and force me to sell you the motorcycle because I was misleading. Finally, where the parties have prior business dealings, those prior dealings will be used to interpret the party's intent in the present contract. Now, you also consider custom and usage, right? And the court will look into that as well. Now, what does this mean? Very, very easy. If you and I have been doing business over a course of time, let's say you're a printer, I'm a paper supplier, and we've got a 4-year contract, and in this contract it says that I will give you paper every month. Payment is due on the first of the following month. Now, 4-year contract, 48 months. For 36 months, 3 years, you paid me on the 15th of every month. On the 37th month, the beginning of year 4, I said, look, I want my money on the 1st. You pay me the 15th. So what do? I sue you for breach of contract because you didn't pay me as specified in the contract. Well, the court's going to go back and look to see what we've been doing for the past 3 years, right? And because for the past 3 years, even though the contract said payment due on the 1st, you've always paid me on the 15th, the court will interpret that to mean, based on our prior dealings, that from the 1st, you had a 14-day grace period before payment was actually due. Why? Because that's what our prior business dealings showed the court. Now, when considering custom and usage, a court will look at the customs and usage of the trade of a particular business and the locale where the contract was made or to be performed. Why? A lot of times people use standard contracts, right? And in different areas, the customs, the norms are different, right? And in those cases, the court will apply the norms of the location or the norms of the particular trade involved in the contract.